So, all right. So good evening, everybody. We're happy to have you here. We're trying to be responsive to members' needs, and a lot of you have expressed a great interest in having a UFT Solidarity meeting, a UFT meeting that's focused on member support issues, among them especially dealing with abusive administrators and dealing with observations. So how do we deal with observations? How do we deal with, with abusive administrators? So we've basically turnkeyd a lot of information here, and we are trying to give you the best sources of tools that you need. Of course, the information we have here is not, you know, is not exclusive. A lot of things we may say, you may disagree with, it may not necessarily work for you in your situation, but we're going to do our best. So I'd like to introduce one of our first speakers. I'd like to introduce Quinn Zanoni. Quinn Zanoni is a founding member of UFT Solidarity, and he is a chapter leader in a Brooklyn D75 school. So Quinn, I'm going to share my screen, and you can start taking it away once I have the slides up here.
Thanks, Lydia. So yeah, my name's Quinn. Like she said, I work in District 75 High School, and I'm bilingually certified also. And I've been a chapter leader for about 7 years. And I was also a delegate before I was tenured. And so today I'm going to be presenting about an APPR complaint, which is something that I've gotten to do a number of times personally and with members at my school. And an APPR complaint is when you get to raise an issue with the way that you're being evaluated. APPR is the annual something performance review. It's I'm sure you all know what it is. It's your MOSL and your measures of teacher practice. And you can raise a complaint with any of it, but what I've tended to use the APPR complaint process for is to complain about your measures of teacher practice. So basically, you get observed and your principal doesn't follow the rules, or they give you an observation that doesn't seem to have any coherence with what actually happened in the classroom. So so the process of filing an APPR complaint is actually something that the member does themselves. It's not something where you have the representation of a chapter leader with you at the meeting. Your principal might be willing to allow the chapter leader to come to your meeting if you discuss it with them, but it's not like an automatic right you have. You basically have to represent yourself. That's, according to the rules. So you would file one by going onto the UFT website. And there's a place to file an APPR complaint. And when you file it, you have to do it pretty quickly. You have to do it within 5 days of receiving your observation report, or well, within 5 days of whatever the issue is. But usually it's within 5 days of getting your observation report. And you go in and you have to say exactly what the issues are. So I'm going to go over like what the many different issues might be. And then your principal is going to get emailed a copy of your complaint. They're going to have a few days to review it, and then they have to schedule a meeting with you, and they have to sit down and have a discussion with you about your observation. So sometimes it depends at the school. Like sometimes people have an opportunity to have, even on an informal, to have like a kind of a discussion about their observation. For example, when a principal gives a staff member their observation report. But at a lot of schools, they'll have the payroll secretary or somebody hand the member, or they just put in their mailbox their observation report. And there's no face-to-face time, like for you to receive your report, look at your scores, and then even talk to the principal about, how you felt about the observation. It's kind of like an impersonal thing. So having an APPR complaint is a formal way to have that type of conversation where you can sit down with the principal and you can say, maybe you didn't see me do this, or, I thought this went better than you think because of certain things. So I I guess I'm gonna get into the specifics now. Before I go into this, if anybody out there in the meeting has dealt with principals who've given you an observation that you didn't think was fair, you can put it in the chat exactly what you had to deal with, because even a good principal does things that they don't follow all of these rules all the time. Anyway, so yeah, let me know if there's a specific issues that you're dealing with, and I can make sure to address them. So there's a bunch of technical. So there's like two different things. Like one is there's all these technicalities that you can bring up, like the amount of time that they had to spend watching you, how many people were watching you, when they gave you the feedback by, and basically if they didn't follow those technicalities, you can get the whole observation thrown out, and they would have to redo it. And then on the other hand, what you could do is with the APPR complaint, you could also just complain about like specific components that they rated you on. Like for example, they say like you gave the kids an assessment during the observation and they just didn't rate you on that category. And you think you should have gotten like a 4 on that. You can bring that up. Or you could say, or if they give you a bad rating on a certain thing, say your lesson plan, and you had and you were using the school's lesson plan template and you followed everything to a T, you could say that you deserved a better rating in that category. So what I've taught members to do is, here's my strategy that I'm sharing with you, okay? So the last thing that your administrator wants to do is have to redo your observation. So usually if you bring up an APPR complaint and you say, okay, I want my observation thrown out, you're probably gonna bother your administration. They don't want to take the time to do that, right? So what I like to do is, I mean, in some cases that's the only way around it, but what I like to do is I basically we write the complaint. If there's a technicality, like say they didn't, like usually the most common technicality is they didn't give the person feedback within 15 days. So that they're supposed to email you or say something to you within 15 days. A lot of people don't do that. Any of these technicalities, if they did broke any of these, you can get the observation thrown out. So what you'll do is I'll put in the complaint, I'll put, okay, I didn't get my observation report within 45 days, let's say. And then what I'll do is I'll say exactly what components that they rated that I don't agree with. So say they gave me like a developing in a couple of areas and I think I should have gotten an effective. I'll say, okay, I questioned the students using this type of sentence, this type of question, and I deserve an effective rating according to Danielson. I'll put that in the same complaint. And then when I sit down at the meeting and I'll say, look, I think this should get thrown out, and the principal will be like, no, absolutely not. I'm not throwing it out. I'll go, okay, if you don't want to throw it out, then just up my rating in these certain categories instead. And they would much rather do that than throw out your complaint. So that's my general strategy with this kind of thing. So the screen share went away, but
yeah, because I was actually going to share out some FAQs, Quinn. So some members, of course, have asked us some FAQs about very common issues that they have been seeing in their schools, of course. And a lot of this is very similar to some of the topics you've discussed already. So if you want me to, Quinn, I could go to the FAQs that our members have, or we can talk about some ways that you can fight back productively, like, especially if you feel like you're being targeted.
Oh,
Are
okay.
you good with that?
Yeah, of course. Go right ahead.
Cool, thank you. All right, so unfortunately during screen share, I can't talk. So if you want to just discuss some of these things you see on the screen here, feel free.
You want me to address what's on this screen? Okay.
Yes.
Okay. So yeah, this okay. I think it'd be better if you went back to that cheat sheet one because it kind of has the same stuff but more of it. Yeah, that one. Yeah. So like on the left side, these are mostly technicalities. Like I said, you have to have some kind of feedback within 15 days, which they often don't do. You have to get your observation report within 45 days. They have to observe you. They have to observe you by certain deadlines. Like the first, the informal has to be within the first semester. I think it is. There's a certain date by which point they have to do your, certain observations have to happen by certain dates. Especially they miss those dates a lot of the time. You can have you can have, I think, back to back. You can have two observations back to back within a certain period of time. That is allowed, and people will often complain about that, but I think it is allowed. But you can't have three back to back, and sometimes when the administrator is really gunning for somebody, they'll just do back to back to back to back. They can't do that. You can't have more than three people in the room observing you. It has to be, they can't have like a secretary do your observation. It has to be like an AP or principal. Superintendent, I guess, could do it. And here's a common one. Informal has to be 15 minutes long. I've had my principal at our school, principals are busy. One time I had a principal walk into my room and she just walked, I was teaching and she walked in and she kind of like looked both ways and she says, okay, I get it. She says, I got 2 more observations. I'm going to go do those. I said, you sure you don't want to spend some more time and, see what I'm doing? She goes, no, I get it. So that's not okay. They can't do that. They have to be there for 15 minutes. Formal, they have to be there the whole period. These are all, says your pre-observation, with a formal, the pre-observation and the post-observation have to happen a certain time. And so like, basically any of these technicality things, you can get it thrown out. Now, the issue with anything having to do with an observation, it's like you can't really prove any of this stuff unless you did this one thing you have to do. You must do this, especially if you have an administrator who you think is not your friend. Is you have to be ready to record your observation. So if you have I know like everybody else in the world has a smartphone, so I think you can pull that out and kind of surreptitiously do an audio recording of your observation, or you can buy. I have like, I think it's in my drawer here. I have this like USB thing. It cost me like $10. It's like a USB stick, and it's like this is a recording device. You like hit a button. They would never know, So it's this one. See, isn't that cute? Anyway, you want to see? My daughter wants to see it. Okay, here. So anyway, you can record people. You have to record people because otherwise you'll say they didn't do it for 15 minutes. It was a 3-minute observation, and you can't prove it. So record your observation. And it's I think Johnny's going to get into this later in the meeting, but it's completely legal in New York City, New York State. It's legal to observe people. I've brought it up at meetings many times. Probably the first time your administrator knows you're like recording them, might freak them out. But after that, they're going to know that you are going to observe them, and they'll just get used to it. And like, it's not a big deal. I mean, they ask to videotape you, so it's not like that weird. So yeah, go to the next slide.
5. We talked about 5.
5 days.
Oh, 5.
So another thing, I go to the one with the one you had before. Other one. Other one. Okay, so here's another one. It says the evaluator includes evidence for 1A, 1E, or 4A. So those are taken more than 15 days. So like, nothing in it can be in your observation that has anything to do with like, that's like older than 2 weeks ago, basically. So basically like, especially in 4A, they'll put if you had a late IEP or you, I don't know, whatever it was. So they'll try to just throw a bunch of stuff in there to 4A about like how you didn't do your job. And if that was over 2 weeks old, they can't do that. That's another one. Also, if you ever here's another thing to know. If you guys ever get observed by a coach, so some people, especially new staff, they will give them lots of support, and they'll send coaches in from district office or whatnot, or they'll have like an in-house coach. And those people will come in and they'll tell you that they're your friend and this is not for stakes. They'll say like, oh, I'm not observing you. This is not, this doesn't count for anything. And then they do it, and then they do write-ups, and those write-ups can go into your 4A. They can use like whatever they give the principal from those write-ups, they can put it in your 4A section, and they know that and they do that. So that's another thing to be considered. Like if you ever have a coach come in your room, just remember that they can actually, it is for stakes. So keep your eyes, just be on your game when coaches come in. The principal. So yeah, I go to the next slide. Mosel stuff. I don't know if I should get into Mosel stuff. So yeah, I don't know. I could
some more of the frequently asked questions, because a lot of our members are dealing with a lot of extreme measures. So I mean, I think it's pretty obvious based on what you've been telling us, Quinn, is that you have to really know and you have to be on your A game. And if you're basically not on your A game, they can basically walk all over you. So when we ask folks to register for this workshop, we ask folks to share some frequently asked questions. And some of these questions, I made a list of the top 4 commonly asked questions. I share these questions with Harvey Ellen Tech. So Harvey, do you want to do a quick introduction as to who you are and your role with Solidarity, please?
Okay, I just unmuted. Can everyone hear me? Yeah?
Yes.
Okay, well, my name is Harvey Ellen Tuck. I have a YouTube channel where I'm soap lover and I play classic soap opera theme songs on the organ and synthesizer. And I had 2 litigations with DOE. The first one was Ellen Tuck versus New York City Board of Education. That's where I was challenging a discontinuance of probationary service and a U rating. And that basically got thrown out based on statute of limitations. Even though I was timely with the challenge of the U rating, they said that I wasn't on challenge of the discontinuance. And that was from junior high 93 in District 24. And I guess it was about 2 or 3 days after I was discontinued from junior high 93. I was rehired at Grover Cleveland High School, and I stayed there till retirement. I had retired from Grover Cleveland in 2011. Now, in 1988 it was, I had filed a Freedom of Information Law request with Community School District 24 for 3 types of documents, which I knew that they would have in their files. I had asked for all of the unsatisfactory lesson observation reports in the possession of the community school board or the community district. I asked for all the chancellor's committee reports, in the possession. And I asked for all of the education law 3020A panel reports in possession. And the records access officer of District 24 denied access. I appealed it. The records appeals officer also denied access. And then I went to court. And the Brooklyn judge supported the denial of access based on FOIL section 87.2G, which says that agencies don't have to give you documents which are interagency or intra-agency materials, which are not statistical or factual tabulations or data, instructions to staff that affect the public, final agency policy or determinations, and then they added yet another category, external audits. So I appealed that to the appellate division, the second appellate division, and I went to court for oral argument in 1994. And I took the position that there were certain facts and statistics and observation reports. And the DOE, they were being represented by the Corporation Counsel's Office. My lead respondent was Chancellor Richard Green, so that case was called Ellentuck versus Green. And during oral argument, one of the judges asked the city's lawyer and also commented and said, oh, surely, Mr. Schwartz, there must be some statistical or factual tabulations or data in observation reports to support the opinions that are there. No. And he said, well, it is our position that there are no statistical or factual tabulations or data in observation reports. The judge said, I see. And then about a month or two later, they issued their decision, and the appellate division supported the lower court, and they denied access to all of the records that I had been asking for on specifically those grounds. And statistical or factual tabulations or data, that means statistics, it means facts. So the court was saying there were no statistics in any of the three categories of records that I asked for, and that included the unsatisfactory lesson observation reports in every single school in District 24 or in the community school board's possession. Now, even though I lost that case, and by the way, I tried to get into the Court of Appeals and they wouldn't review it. So the appellate division's decision that stood. But this decision, I felt, benefited teachers because now they can say, hey, you're disciplining me based on my observation reports, but there's no statistics in them and there's no facts. The appellate division said that they consist solely of advice, criticisms, evaluations, and recommendations. So it really was of no concern to the appellate court that there were no facts and no statistics. It was okay with them that all these documents are being generated based on opinions. I notified the UFT about it. They didn't really care about the issue. And then years later, Michael Mulgrew filed a litigation in connection with teacher data reports. The UFT did not want DOE to release teacher data reports to the public. And in that case, the lower court judge, who was Judge Cynthia Curran from Manhattan, she said that the UFT's reliance on my case was misplaced because my case had to do with observation reports, which are opinions, but the teacher data reports, they contain, statistics. So the UFT appealed that to the First Appellate Division. The First Appellate Division supported the lower court. They tried to get it into the Court of Appeals. The Court of Appeals wouldn't review it. So in that case, DOE released all the teacher data reports with the names of the teachers in them to the media. And it was covered by, TV stations, newspapers. It was a whole big deal. So eventually they added a new section to the education law to make documents which are used in evaluating teachers and principals inaccessible to the public under the Freedom of Information law. But nonetheless, parents have the right to know the teachers or the principal's final rating from the preceding year, as long as they still have students currently in the school. So so the DOE basically considers me as a career litigant. I also had a commissioner's appeal where I was trying to get other records out of District 24 under a section of education law, and that appeal was dismissed because the commissioner said it's really a Freedom of Information law request, and it has to be taken to court under the Freedom of Information law. So anyway, nowadays, I try to help teachers. I give advice to them, and I point out to them that when you're challenging observation reports, one of the things you should be doing is asking the administrator, is there any statistical data in the reports? Is there any factual data in the reports? If so, please identify it. What are the facts? What are the statistics? And they've probably been told by the senior field counsel not to respond to questions of that type, most likely.
Oh, and just an FYI, folks, for folks who don't know what senior field counsel is, basically every single DOE attorney, regardless, their rank, their tenure, they all have been assigned an attorney, and these attorneys basically advise principals on the things that they can and cannot do. So principals are basically, beholden to the lawyers, and the lawyers and the DOE are the chancellor basically answers to the lawyers. So whenever you deal with a legal issue in the DOE, you may see a name CC'd either on an email or below a letter that you may not necessarily recognize. And usually that person is someone from the district office or central who is an attorney. So I'm going to share now a few frequently asked questions. So Joanne, if you could you share the PowerPoint now and start slide 9? Okay. So we took a few of your
hear you.
most popular common questions, and a lot of you asked very similar questions time and time again. So our goal here, we try to simplify a lot of your questions and concerns to the top 4. Joanne, are you able to share?
It is giving me a triangle with an exclamation mark in the middle of it for my main screen, and I'm not knowing why.
That's very strange. Okay,
I'm going to try to
Sorry.
troubleshoot, and I'll keep you updated.
Sure. No worries. All right, folks. So I'm going to share a copy of the PowerPoint in the chat. So folks, if you are able to open up this link in the chat, you should see this PowerPoint link. You will be able to open it up and access it. And we're taking a look at slide 9. So these are some very frequently asked questions about the APPR. So one of you asked me, why are observations used as a form of punishment? Like, why on earth do we do this? And basically, observations have always been used, unfortunately, subjectively, as old as teaching has been. And Harvey did a really good job of doing research. If you are interested, for example, about learning about the whole litigation process, about how the law has been used to demean teachers, and also how you can use the law to fight back, I strongly recommend this book, Teachers on Trial by Professor James Gross. Basically, whether you are tenured, whether you're a probationary, observations have been used as a form of punishment. But as Quinn has hopefully taught you, as Harvey's hopefully taught you, there are ways you can fight back. So, of course, as Quinn mentioned, there is a 5-day statute of limitations. It sucks, it's narrow, but it is the way it is. So you need to act fast. But of course, if you're concerned, for example, that your principal isn't going to, follow that complaint, if you think your complaint isn't going to go anywhere, you can just simply then kick up this appeal and you can actually file an appeal at the state. It's called Educational Law 310. You can find information as to how to file one of those appeals on the UFT Solidarity website. So on the last slide that I'll share with you all, you'll be able to see basically how to contact us and our website. I'm going to go to the next slide.
You can also file a rating appeal before that, I would say. If your rating is developing or ineffective, you can ask the UFT to intervene. And I don't mean your chapter leader, I mean people at the DOE headquarters. And they only accept 13% of the complaints filed for the year. So if you think there's some kind of flagrant violation in your observation, then you can reach out to the UFT. You can reach out to your chapter leader or district rep or call the UFT, and you can submit you submit a complaint in which you include your observation, your past 2 years of ratings. If you feel you've been retaliated against, you make an argument why you think that's the case. And then again, they'll select 13% of the most compelling complaints for the year, and then the UFT will go to the city to try to get it completely overturned. That's also another thing you can do in addition to an APPR complaint or going to the commissioner.
Thank you, Quinn. Another person asked us, can anybody file a complaint? And yes, anyone can file a complaint. Now, if you are untenured, do you not necessarily want to stick your neck out, especially if you have an abusive principal? You know, that is definitely up to you. You know, I am of the mindset where, like, if they are out to get you, you should make it your best interest to hold them to very high standards as well, and you should make sure that they are following the letter of the contract and the letter of the law. You know, that this is just something that I will always live on and die by. Even as a probationary teacher, you know, I got in trouble for holding my principal accountable, but do I regret it? No, because my principal's put it on notice. And I think it's just knowing, you know, what are you most comfortable with doing? Like, you know, if you're comfortable with filing an appeal and you're probationary, go for it. If you want to just wait it out and see if you can, you know, stay in their good graces, or if it's really not a huge issue, let it lie potentially. All right, so I want to introduce now Jonathan Hinesley, because I know we're running out of time, folks, and I want to make sure we're able to finish a little bit after 6 o'clock today. So I'm going to introduce Jonathan Hinesley. Jonathan Hinesley, like Quinn, like myself, he is one of the founding members of U of T Solidarity. He is a former chapter leader, and now he is a delegate at a Bronx K-8 school. So Johnny, welcome. I'm going to Joanne. Yeah, very good, Joanne. So Joanne, if you could you start at slide 12? So Johnny and I can like be able to like jump in and talk about how to's with dealing with an abusive admin. Thank you. And if you want to go to slideshow, Joanne, that'd be helpful.
Can you guys hear me?
Yes.
Yes.
Yep, you're good.
Okay, so I did want to add something with the you can file something with the Office of Appeals and Review if you're trying to appeal your overall rating. And if you're going to file an education complaint with the Commissioner of Education of New York State, you have to go through OAR first. But you should be writing up both complaints simultaneously. And then OAR will call you. But you should, if you want to file an APPR complaint, you got to do that right away. And the union does give out a cheat sheet of things that you can grieve. And it's a very tight list about what you can and can't grieve. And the principal has the right to their opinion, and you don't have to agree with it. So they'll get away with, as long as they don't do anything egregious, like not give you feedback before 10 days, not give you the write-up back in 45 school days. If they don't break one of those big rules, the union doesn't usually step in at all. Getting one of those 13% complaints is very hard to come by. But like Lydia said, that doesn't mean you shouldn't fight back. That doesn't mean you shouldn't be trying to protect your career. The one thing I would say is, if they're coming after you, they're coming after you. They're not going to stop. You're not going to play nice with them. But if they just gave you a bad observation and it's a one-off observation, then like Lydia said, you might just want to, wait it out. But if they've decided they don't like you and they're coming after you, it's not like fighting back is going to stop them. Or excuse me, it's not like not fighting back is going to stop them. If they're coming after you, they're not going to stop. They're just going to keep coming after you and do what they feel like doing. So fighting back at least maybe makes them think about it. Because if you're in danger of getting an ineffective rating, they have to give you a teacher improvement plan. They have to put things in place that help you improve. And what happens is that's a lot of work for them. They actually have to do work. But if you don't hold them accountable, they won't do it. And nobody above them is going to make them do it. So by you fighting back, you make them do that work. So maybe they decide when you give them all that work and you start making a paper trail that they don't want to do that work, that it's too difficult, and they decide to go after somebody else. That's my little spiel right there.
Thank you. So Quinn kind of hinted on this before about recording. So basically, one of the best defenses that I have, that I know Johnny has, that Quinn has, about dealing with an abusive administrator, is just being really good at documenting everything. One of our good friends, who is also a council member, Kathy Perez, Kathy would, was in a really tough situation at her middle school. And one thing she would do is that she would record everything that happened. And then she would then sit down and she would then transcribe the audio transcripts. She would sit down with a notebook. She would transcribe everything by hand. Now, nowadays, we have Google, we have OneNote, we have all these amazing, terrific tools that can allow you to record and transcribe things easily. But documentation is your key to defense. It is what's going to save you in the end. It is what saved me from losing my appeal in the DOE. So when I was a first year teacher, I was discontinued, and discontinuance is a fancy word for being blacklisted. Because I was in a high school, if you get discontinued in a high school, you're basically blackballed from the entire DOE system. You're blackballed from all high schools, and it's really impossible and really hard for you to get even into a middle school or an elementary school. So I had evidence that my principal was being biased and harassing me. So I learned how to use my audio recorder, and even for the meetings that I didn't record with my principal, I was just really good at just following things up with an email. So as you can see on this slideshow, unfortunately, our union needs to do a better job at enforcing and going after abusive administrators. We tried to challenge them at the local high school executive board meeting. High school executive board members called on the U of T leadership, you got to do more to protect teachers. You got to do more to protect chapter leaders. And the U of T basically said, well, a principal isn't going to like it if they see strangers walking into their classroom demanding that they shape up or behave. And my answer to that is, you're the union, I'm the union, but everyone needs backup. But so basically, if you feel like you can win at either the chapter, the district level, or the borough level, you might have a shot. So our best advice is to make friends with your district rep, your DR, and make the case for them to advocate on your behalf. Ideally, if you have a group of teachers who are going through the same situation as you are, go together to the U of T office. That way they know it's not just one disgruntled employee. That way they know it's a whole bunch of you. But that's hard. It's really freaking hard to do that. It's hard to find the courage to do it. But keep in mind, folks, a lot of our DRs seem to be in pocket with the admin. In that case, go above their heads, go to the borough rep, go to the safety officer for each borough, especially if your principal is doing things that are causing danger in the school. Like if kids are getting away with beating teachers up, you might want to go to the safety officer and complain. If kids to your knowledge are bringing weapons, and your principal's sweeping under the rug, and and you're a dean, you know for sure that proper protocol isn't being dealt with, you bring it up. So if you are new to a solidarity meeting, you should take note that this is a website that you should all be familiar with. It is called solidarityuft.org. If you go to this website, you will be introduced to our website, and you will be able to click on the toolkit. Our toolkit has a ton of information as to how to defend yourself against an abusive admin. Joanne, could you please go to the next slide? Thank you. So again, all about documenting, keep a written log of any kind of harassment. And harassment could be small. It could be, excessive observations. It could be a meeting that seems positive and then turns negative. And then your principal says, oh no, we're not going to stop right now, because I want to bring something up that happened last week. Or a student said this about you. Is this true? Keep in mind, folks, that if you are in a meeting with your principal and it turns into disciplinary in nature, or your spidey senses feel like something is up, you have the contractual right of stopping that meeting right now, right away, telling, we're going to continue this conversation when I have a witness. Now, always good to have your audio recorder running. When you go into a meeting with an admin, even if an admin like, oh, she's my AP, yeah, she cool and stuff. Yeah, we cool. No, your admin can turn you in a heartbeat. Remember, they are not in our same union. They don't know loyalty to us, unfortunately. They are under pressure and they're scared the DOE may go after them. So they're going to do whatever they can to try to avoid, just to try to avoid being caught up. So they're going to go after you. Go to the next slide, please, Joanne. Cool. All right. If you have a phone, feel free to go to this QR code. It is called the UFT Solidarity Ultimate Survival Guide. So if you go to the UFT Solidarity website, solidaryuft.org, and you click on Toolkit, there is a survival guide. I'm going to drop the link here. So basically, this covers all these simple to-do lists of everything that you could do for yourself if you are under attack, whether you are tenured, untenured, if you are a paraprofessional, if you are a substitute teacher. You can go to this Ultimate Survival Guide and you can use it to your heart's content. Let me find it. Here it is. Okay. Let me drop that in the chat, folks. Feel free to open up this link, bookmark it, save it, share it with your friends. Joanne, could you go to the next slide? And Johnny, if you want to jump in and add anything to it, feel free.
Yeah, if you're gonna record, like anytime you're called into an administrator's office, you should record. Don't forget to put your phone on airplane mode so that it doesn't ring and you don't get text messages in the middle of your recording.
Yeah, that would be very awkward and bad. So again, I'm going to reiterate my rule of thumb. If they are going to make your life a living hell, you have the full right and honor to make their life a living hell. Now, if you feel comfortable doing this, go for it. Even if you're the type who isn't super confrontational, it is always better to be assertive. My rule of thumb as well, better to die standing with your sword or a quarter or legal brief raised than to be in a fetal position and let them kill you. Joanne,
the other part is you don't have to be confrontational in person. You could just document everything in writing. You can go home to your safe space and write an email.
Joanne, next slide. Thank you. Perfect. Very good. So these are some questions that you all shared with us. So I took a lot of these commonly held questions. Harvey helped me do a really good job at answering some of these really, professionally and really short and sweetly. So a lot of you asked this very common question, as so many of us have. And I'm not sure if it was rhetorical or not, but I took them all with a grain of salt. But basically, why are superintendents not held accountable when they have data and surveys about abusive principals and high turnover? Well, probably it's most likely politics. Remember, you become a superintendent based on who you know. It's not necessarily whether you love education, whether you love kids. It's how connected you are. Some superintendents are great. Some superintendents, as we know, are awful. The superintendent who discontinued me was later on fired from the DOE for hiring her relatives. I'm sure we all know principals and APs who have done, and superintendents who have done this thing. Remember,
my superintendent was fired. Well, she was replaced because she said she wouldn't do the forever. Misha Porter fired her, terminated her, and she filed a harassment suit that got thrown out of court. So as soon as someone picked on her, she crumbled too. But meanwhile, she'll sit there and watch other people get picked on.
That's it. Also, superintendents are probably not being monitored by the community education councils, chancellor's office, panel of educational policy. So it's up to us. It's up to us to talk to parents. It's up to us to talk to our community members who may not necessarily be employees of the DOE to go to CECs, go to community education council meetings, go to panel for education policy meetings. They're being held remote now. There's really no excuse. We can talk to our neighbors. We can talk to our friends about attending these meetings and bringing things up. Remember, if you are not in the DOE, if you're not a DOE employee, you do have a little bit more protection because they can't go after you. So like for me, myself, I'm no longer a DOE employee. If there's an issue going on, I'm an employee of the New York City Public Library System. I have a different union. I could go after people in the DOE now very freely, more freely than I could before. So see if you can find allies. Find allies in the community if you're dealing with an abusive administrator. There are people out there. People will listen. Now, as to what recourse do staff have, as Johnny said, make secret recordings. This next bullet point actually kind of reminds me of something that one of my good friends, so one of my friends, Asia, who is a Solidarity member and a good mentor of mine, she was in a school that was very toxic and her principal treated her very badly. She was desperate to get out of the DOE and get out of the school. She had been trying to get out on a safety transfer for a while, and her admin refused. One day, she was staying late in school. She came into the office and she found her principal in a very compromising position with another teacher. Using her smartphone, she recorded. The next time her principal tried to do something nasty to her, she played the recording and said, "What would you do if this suddenly was leaked to the news?" And the principal then sat down, closed the door, and said, "What do you want?" "I want a safety transfer." And he gave it to her. You may not necessarily find the holy grail like that, but if you have enough information that shows your principal in a really damning light, it could be worth showing a trump card. For me, I never showed my trump cards when I recorded. Never did. The only trump cards I played was once I was in court, and I played it for the judge, and I played it for the DOE attorney. But if abuse is related to observation reports, you could always file a suit. Harvey, Johnny, do you gentlemen want to hop in and highlight any of these previous points that I mentioned?
In terms of commissioners' appeals, I think what we should do is maybe examine some of the decisions in previous cases, and also maybe look over some of the pleadings in the recent cases, and see to what extent the state ed department is treating the pleadings seriously. So far, they don't seem to think too much of my case. They don't seem to feel that it's that important that the observation reports contain, opinions and advice only. So to that extent, we may have to change the mindset of the lawyers who work for the state ed department and who write up the decisions on behalf of the commissioner.
Yeah, I wonder what will happen if the state of New York was suddenly flooded with all these, with all these appeals of people appealing their observations, saying like, my observation was, contains absolutely no facts or statistics. One thing you could do to really back up your point, this is something that I did when I sued the DOE 10 years ago. You could actually file a FOIL request for observations. And the irony is that the DOE is going to deny it, not just because it's a violation of privacy, of another person's privacy, but also because they will cite legal precedents saying like, we're only allowed to give you information that contains facts and statistics. So they'll probably end up giving you like, an observation report that only contains a person's like first name, and that's it, and the date. And that's really essentially all that you can really state for facts and statistics. The principal came in on December 15th. There were 24 students present. As a principal, I stayed 10 minutes. There was something written on the board. The sky was blue. Lights were on. That's it. All right, Joanne, could you go to the next slide, please? All right. Someone asked this question. It's really near and dear to my heart. But basically, can you transfer due to anxiety caused by abusive applicants? A lot of us have been in the DOE for a long time. And of course, as you know, if you've been in the DOE for a long time, it's often very hard to transfer because you're expensive. and principals, especially now in this time of uncertainty regarding budgets, principals are trying to be more and more careful. But yes, you could do a few things. You can't necessarily transfer due to anxiety and not just wait until open market. But in order to do that, you have to put pressure on the DOE Division of Human Resources. If you're turned down, you can always file your appeal in the court. You can file a law 310 appeal within 30 days of receiving, any kind of, response. You can also apply for a FEMLA. So FEMLAs are unfortunately unpaid. You'll be able to keep your insurance. You'll be able to get a small stipend for emergencies every week. But this is an option that you could have. You can take a FEMLA, I believe, for up to 12 weeks for yourself. You can also apply for a medical sabbatical, which are paid at 60% of your yearly salary. However, if you have, if you have less than 7 years in the DOE, you cannot file for a medical sabbatical. If you have between 8 years and 14 and a half years, you can file for a half-year medical sabbatical. If you have 15 years or more, you can file for a full-year sabbatical. SOLAS contains the application information and deadlines. So there are deadlines for being able to file for a medical sabbatical. FEMLA, you can take at any time. What would you do if you took your admin to court and the arbitrator sides with the admin? Someone asked me this. So basically, you can file an appeal at a higher level. So for me, I was discontinued 10 years ago. I was probationary. I filed an appeal at the Office of Appeals and Reviews, and unfortunately, the arbitrator sided with the principal. So what I did is that I knew I had between, I didn't file the 310 appeal. I filed what is called an Article 78, which has a statute of limitations of 4 months after you get an administrative decision you don't like. Again, if you go on U of T Solidarity, you can actually find information about how to actually file an Article 78 or an ed law appeal on your own. So I'm going to drop in this link right now. So the link in the chat that I'm sharing with you right now is a good tool for talking about legal supports. These are talks about different legal supports and different suits you can file on your behalf. So I filed in the courts. I filed my Article 78. Thankfully, since my principal was very corrupt and I had documentation of how corrupt she was, I was able to win my case. So that's one thing you can do. Johnny, you want to add anything?
No, anybody can file an Article 78 for any anything you disagree with that's an administrative decision. Harvey, has Harvey talked about the city charter? I chimed in a little late. I'm sorry. I apologize about that. About using the city charter to push back against administrators that are filling out documents, official documents, and they know they're lying. They know they're not telling the truth, and they might not even be aware of the city charter. I did have a conversation. I became an ATR, and I had a bunch of run-ins with principals that wanted to come after me because I was an ATR and because I had fought against the DOE and a corrupt principal. So a principal tried to give me an observation report, and it was full of just blatant lies. And I just brought up the city charter, and it's 111B. And it says any agency lead that falsifies an agency document is committing a misdemeanor and can forfeit their job and spend up to 6 months in jail. And last I looked, that's still on the books. But you have to be real. One thing I meant to add this a little earlier. When your principal walks in, if you have your clipboard, you could start recording with your phone. You have your clipboard because you're taking notes. You're taking notes from the students. You should write down what your principal does. What the administrator does, the administrator came in and sat down at this table. They didn't talk to any students while they were looking at the observation. They were texting, they were on their computer, like everything that they do. You should talk about you should write down how many kids were in the room. You should write down your lesson. You should document your learning target, what was on the board. Then you should take pictures of this stuff. So anything that's inaccurate, you now can push back with, you know what, you came in my room and there's a lot of inaccuracies in this. You know, you can lose your job for that.
Okay.
And, you know, it's a pushback.
Oh, Johnny, someone just asked a really good question. Are admin allowed to take pictures of you when teaching and observing? This member said, mine took pictures of me while teaching, and why would that happen?
They should not be taking pictures of you, but they can take pictures of like your charts and students' work. The union never pushed back against that. So they can do that, but they shouldn't be recording you, or I don't even know why they would take a picture of a teacher. They might take pictures of like your learning standards, your success criteria, stuff like that. But you personally, no, that's a little creepy.
Harvey, do you want to jump in and talk a little bit more about the city charter, or do you think Johnny covered it?
Oh, let me mention this too. If your principal is attacking you, you should absolutely not sign anything that's late. You should make them do their job correctly. So if they come in and they're supposed to give you feedback after 10 days and they take 20 days to give you feedback, I'm not signing the document. You have 45 days to give me my observation report. You gave it to me in 46 days. I'm not signing it. And I'm filing an APPR complaint. The minute you're in danger of getting a U rating again, or an ineffective rating, they're supposed to put in supports to protect you. Make them put in the supports. Make them put in the supports, because that's work on their part. So don't let them off easy by, you know, ducking and covering.
Agreed. Another good thing that might be really good, especially for tenure teachers, the U of T has something called a PIP Plus. So PIP basically is it's a tool the union has to give more coaching and support for tenured teachers. So if you're tenured and you think your admin is gunning for you, if you request a U of T teaching coach to come and observe you and work with you, your principal basically cannot observe you for 6 months. So basically, if you feel your principal is targeting you, you know, you can actually call the U of T, said, I want to be hooked up with a teaching coach for PIP. Usually if the DOE U of T will approve it, and then your principal can't observe you because you're working with the coach. So this is one thing you can do to potentially stop the clock of observation. And Harvey wants to make Harvey dropped Harvey share with me the link.
Yeah, I just sent the link, right?
Thank you, Harvey. I'm going to drop it in the chat for everybody. And the administrative code is actually 1116B. Okay. All right. Joanne, could you go to the last slide, please? So I want to make sure we all have time to actually do it after this one.
Hey, I would like to ask a question, quick questions.
Sure, Joanne, if you want to just pause. So just as a quick reminder, this meeting is being recorded. So if you don't mind having your voice on camera, feel free to speak.
Okay. I would like to know, in your experience, what is the quickest, what is the fastest, the less time that the DOE get rid of incompetent teachers? How long does it take the process, in your experience?
In
Can
my
you tell us,
go on.
is this a tenured teacher or
Yes,
a
tenure.
non-tenured teacher?
No, tenure.
2 years. It
2
takes 2
years?
years.
Okay.
Yeah.
That's the fastest way that they can get rid of it. I mean, the
So
whole
what'll
process you
what'll
mean, when they file the charges, how long does it take?
that depends on how many cases are in front of you.
Okay.
That depends on how quick the union gets you representation and what the union lawyer's caseload is.
Okay.
Because what'll happen is you have to be assigned to an arbitrator. After you're assigned to the arbitrator, you got to have preliminary hearing. You got to have time to meet with your union lawyer.
Yep.
So as soon as, okay, if you've received charges, you need to go to the union immediately and tell them that you disagree with the charges and you want to be assigned a lawyer.
Okay.
Once you get a lawyer, you have to meet with that lawyer. Then the lawyer will go with you to the arbitrator. At the first arbitration, you meet the arbitrator, you meet the DOE lawyer, and your lawyer asks for all the documentation that they're using against you.
Mhm.
So they have to turn that documentation over. And then you're given some time to go and look at all that documentation and present and create your argument.
Perfect.
Because what'll happen is they're gonna throw everything at you. If you were absent 11 times, you had 10 doctor's notes, they're still gonna say you were absent 11 times, and they're gonna have your doctor's notes disappear. So you're gonna have to go back and get your doctor's notes again. They're gonna say, oh, remember that time you had an unexcused absence where you were 15 minutes late? You got to go back and get any documentation you turned in. Because the stuff that protects you is gonna disappear. The stuff that they want to, and they will add stuff in. They will throw new stuff in that you never seen. So there'll be counseling memos that you never signed, and you're gonna say, you know what? I never signed that counseling memo. I was never given support. If you were given support, they're gonna have to explain. They have to give you all the documents, so you'll know the case against you. So you and your lawyer can make the case to defend you. But you really have to go through that with a fine-tooth comb, and you really have to think about what they're using. It's not easy and it's very stressful. If you find yourself in a 30-20, you should want it open to the public so people can show up. You should make sure that you need to make sure your UFT lawyer defends you, because they're very lazy. So you have to become kind of your own lawyer and paralegal to make sure the lawyer gets the case right. So like you should be very vocal about that. Remember, they work for you. You've been paying them for years. They should do their job.
All right, folks. So we're going to go to the last slide of the PowerPoint because it's already past 6. You know, I wanted to get you guys out of here by 6 o'clock. I know we're all busy. Joanne, if you could go to the last slide. But basically, I know a lot of you have been really good at sending me individual questions, and I appreciate that. I think one big takeaway from this workshop really should be the importance of fighting back and knowing your rights and just being able to stand up for yourself. Joanne, next slide after that, hon. All right. So this is the email that you can reach Harvey, Johnny, myself, and Quinn. If you go to UFT Solidarity Help at googlegroups.com, you can send us a direct email. Especially if you're having a complicated or a sensitive issue, feel free to email us anytime. Again, solidarityuft.org has a toolkit for folks who are going through the 3020A. We have a special section for you. For folks who are probationary, we have a new teacher guide for you. If you're dealing with any other kind of issue, we have all these great resources for you. If you want to bring up your situation at the UFT Executive Board, you can also email UFT Solidarity Help, and I will get you in touch with Beth Mejia, who is our UFT Solidarity representative at the Executive Board. And that is really essentially it. I want to thank Johnny and Quinn for sharing. I want to thank Harvey for helping present and doing research. I want to thank Joanne Millar for doing all the tech and just setting up the Zoom for us. I want to thank Dan and Lawrence and Winton, who are members of our council, for coming. And I want to thank you all for coming. You know, we wouldn't have had this meeting without you all. So thank you very much from the bottom of my heart, and be well. I'm going to end recording. Great, excellent. All right, everybody. So feel free to share out in the chat now. Otherwise, we are going to be, I'll close the Zoom in about 2 minutes, folks. So you all are dismissed. Have a wonderful evening. Thank you, Alma. Thank you, Lily. Miss Barium, I'll look up the lateness policy. Quinn, thank you.
Thank you. Yes, thank you.
All right, everybody, be well. Take care.